Good afternoon. Before I begin, could I just ask everybody, and this ought to have been done automatically, to mute your microphones and to switch your view to speaker, which ought to be on the top left-hand side of your screen. It's incredible to see all of you there. If I can just ask you to mute your microphones again. Thank you. As I'm speaking, the number is ticking up, and at the moment we've got about 280 people online, which is quite incredible for this type of event. So good afternoon, hello, my name is Sam Karim. Thanks for joining me in a short conversation with four of the most prominent members of the judiciary discussing practical implications of the rule of law by reason of COVID-19. If I were a talk show host, I would describe all these judges as A-list celebrities in their own right, and I'll come to them individually in due course. But if I can just say a few words in opening, which are these, that some of you may have heard recently the statement of William Gladstone, a prime minister in the 1800s, who said that justice delayed is justice denied. And that's a statement that is relevant now as it really as it ever has been. And we really don't have to go back much further, because if we go back to the Magna Carta in 1215, I think clause 40 reads that the right of justice is not to be refused or delayed. But why, you may ask, is all this relevant now? Well, there's a good article by Jake Richards in the prospectus, who on the 18th of March said this, and I'll read it, which is that the effect of coronavirus on many industries and sectors operate is likely to be profound. For the justice system, our reliance on disparate groups of people meeting in a room in localities across the country is archaic. He went on to identify that during this period, we as lawyers and the judiciary and the justice system in its entirety may struggle. But he said that from chaos comes change. And in support of that, he looked at the Second World War when he said this, that the courts encountered immense challenges during that time, often in surprising areas. In 1944, it was the rise of divorces due to the strain of the war, compounded by the lack of available lawyers, that led the government to appoint a committee led by Lord Rushcliffe, a politician and barrister, to consider access to justice. The Rushcliffe report eventually led to the creation of a key pillar of our justice system 70 years on. And isn't that quite fascinating? So you may all ask, where does this all take us? Well, that's a very good question.
Paula Johnson.
And if I can just offer three thoughts before I hand over to our illustrious panel. Perhaps COVID-19 will be the incentive for the use of technology. Perhaps we may look back at this episode as the beginning of a vital shift in the means of which justice is administered. And perhaps this is the beginning of online judging and courts, which is a concept advanced by Professor Richard Susskind, which for anybody who's interested is a vital read, his book Online Courts and Online Justice. But who knows? Bloomberg reported last month that the British justice system is based on tradition, and the coronavirus outbreak, in their words, isn't going to change any of that. To that end, and certainly in my experience, wherever possible, we've been moving forward, adapting to procedures to hear hearings by telephone or by video. And finally, comparatively, our justice system is looking better than most during these difficult times, but that, in my view, should not be our goal. Our goal should be to use this time to reconsider and benchmark best practice methods for dispute resolution, be that in person or online, to inform how we operate in the future. So how better against that background, and who better to discuss all these practical implications in all the various civil jurisdictions than the panel today. We have, first of all, the Right Honourable Sir Ernest Ryder, President of the Tribunals, Mr. Justice Hayden, the Vice President of the Court of Protection, Mr. Justice Waxman, a judge of the Commercial Court and the Technology and Construction Court, and Mr. Justice Julian Knowles, who is the Administrative Court Liaison Judge to the Northern Circuit. Thank you all for accepting my invitation to speak, and I'm personally delighted to have you all here. If I can first move to Sir Ernest, You are obviously in charge of the tribunals, and the tribunals are responsible, as on my last count, for eight different tribunals, including immigration, social security, employment, and then we have the first-year tribunal and the upper tribunals. What effects is the current physical lockdown having on the work of the tribunals generally, Sir?
Well, we would normally have over 4,000 hearings a week, spread across the United Kingdom, sometimes as high as 5,000, with about 60% or more unrepresented parties or only partially assisted parties. Since March the 19th, we've managed round about 2,600 of those hearings a week. That's not adjournments, that's substantive
Join the meeting.
And we've added to that all immigration bail hearings and a small number of face-to-face hearings. We've only got a skeleton staff, although we're hugely grateful to them for coming in to court buildings, some of which are closed to the public, and B, those who started to work with remote laptops from home, trying to piece together ancient software with the most modern software that we were still developing when COVID arrived. On the 19th of March, I realized my judges were going to be excluded from all hospital sites, so we couldn't undertake mental health determinations, and from a large proportion of our hearing centres. So we moved to single judge remote hearings for all urgent priority work as an emergency measure. And since then, almost all of our hearings have been away from the usual business buildings where most of your contributors today will know it's almost impossible to provide social distancing. We've had emergency legislation and rules changes with sunset clauses to give permission for what we do, and a collection of practice directions and guidance for each chamber and each tribunal, and a help for users document in plain language for each tribunal. That was what we started doing, but we're now into a 4-phase recovery plan. So the first was immediate emergency. Second, where we are now, consolidating what we do in lockdown, returning to the use of panel members and full panels, even remotely, and restarting all paused hearings. We're planning for the next phase.
Join the meeting.
Relaxation or partial relaxation of lockdown, where we'll have backlogs, a lot of new work, for example, in benefits appeals and employment and some mental health. And we've got to find old and new ways to work. And then we're planning for, effectively, what on earth is the new normal when lockdown finally recedes.
Gosh, so in terms of the remotes that are being held remotely, are they also including final hearings in the relevant tribunals?
Yes, not every tribunal. Some tribunals are exclusively paper-based. Reform hasn't got near them yet. And when you're talking about something as difficult as the paper for a veteran's records in war pensions, and it's held in the Ministry of Defence or in a building that's locked in London, I can't access that paper. But by and large, tribunals have gone for either video or audio hearing as their new default during COVID. Video is usually Skype for Business or Microsoft Teams, but we've introduced in the last 6 weeks something called Kinly, K-I-N-L-Y, CVP, which is a hearing room technical solution which is still in development. It'll eventually give you public access by web streaming. It does that at the moment by a telephone channel. Automatic recording, interpreter spaces, privileged room spaces, waiting rooms, and all the sort of things that judges might need in a courtroom, as well as document overlay. And we're trialling it. One tribunal at the moment, that's special educational need, does 100% of its work in that system with a 2 or 3 member panel. So it's exactly like a court of appeal. A hearing can be half a day or 5 weeks. So you have the full spectrum of complexities. And at the moment, the users are unanimous that they actually prefer that to face-to-face hearings. Now, that's very peculiar to their jurisdiction. It fits their vulnerabilities and it fits the process and this is very definitely not for everybody. But it just happens to have worked for us. We've extended it to mental health, and we're starting to go to any other tribunal that needs 2 or 3 panel members so that they can have a genuine hearing and see everybody and talk to everybody. Everything else is audio, that's BT Meet Me. Those are literally hundreds of hearings a day, particularly in Social Security and Children's Services, SSCS. One unintended benefit of all of this is that we're recording all tribunals' hearings, whereas before hardly any tribunals were recorded. Now they have to be to give public access under the new practice directions, and the benefit of that is phenomenal, both for appeals and for writing up judgments and reasons. And Kindle's also allowed us to go back to panels which had been paused. So things like tax, more complex tax, or land, things that involve contested hearings not far different from a High Court contested hearing, but probably those hearings where we're not looking at the credibility of oral evidence, because those hearings, like in immigration, are probably still being paused in the majority of cases.
Right, and bearing in mind the extent of the work in the tribunals, are there any areas in which it's thought that remote hearing is not appropriate in terms of judicial determination? Ernest, before you answer that question, can I just ask and confirm that everybody has their microphones on mute, please, because I think we're getting some interference. Thank you.
Sam, we have identified things that are rightly difficult to do in a remote setting, and which will they're therefore by and large proceedings that will be paused for the moment, and we'll deal with them as case management or urgent issues only. I mean, for example, quite a bit of immigration where there's an inevitable interpreter and oral evidence is hugely important, and a credibility issue can determine either detention or the removal from the jurisdiction. At the moment, very few of those are being held by remote, although we do deal with the bail applications. And even when we get into the new online system in immigration, there'll be a case management review in order to look at the issues before we determine whether remote is appropriate. So that's an example, I think, where we're being rightly cautious. Some of the longest hearings, for example, in the employment tribunal, we're being very cautious about. They're complex, they rely on oral evidence, discrimination claims, and equal and fair work and terms and condition claims tend to be a few weeks in length or have multi-party aspects to them. And so those tend to be being put off at the moment and just case managed. But quite a lot of other stuff that people wouldn't necessarily have thought of has turned out to be suitable. So things in the upper tribunal lands and upper tribunal tax, in the tax chamber itself for most of the smaller things. And if you want a remote hearing to go ahead, you're probably going to get the go-ahead from the judge at the moment.
And so, Ernest, finally, you mentioned some new technologies that have been utilised since the physical lockdown. But do you think that the current situation has brought to the forefront the use of technology and the usefulness of it in the work that the tribunal does?
It's forced us into that place. So we've had to use things that weren't completely developed, like Kindle. It's forcing us to develop them at pace, and also to evaluate what we're doing at pace. For example, we have coded every decision we've made since the 19th of March.
Join the meeting.
So that we can evaluate it. What type of remote was it? What was the feedback like? What do users and judges think about that? And there's a huge HMCTS evaluation program about to kick off using the coding that we put into our reasons and orders. And there's also some new ideas that have been trailed by practitioners. I mean, this has led to a lot more signposting of advice, a lot more help from the advice sector working online. Without them, we couldn't have done a lot of what we've done. Pro bono practitioners, again, huge effort, made to get us where we are. And some of the new ideas build on things that we've been doing in a small way. Just one example is ADR. The enthusiasm for ADR by remote. So for example, a judge mediator in an employment tribunal, or somebody doing early neutral evaluation in triage, has become much greater than it ever was. So people are wanting an indication, accepting it when it's given, and that includes government departments and agencies. So there's a change not just in practice, but also in perception and what people want. This has opened up doors that people didn't think of. I mean, children gaining access to special educational need tribunal hearings used to be a rarity, even though they can and should, whereas it's a commonplace by remote. And there are some interesting implications for that, and some very interesting and important questions about vulnerabilities. We really do have to think about which system suits the vulnerabilities of our users. It very definitely isn't a one-size-fits-all. There are some things that really do not work for some people, and other things that actually help them in their access to justice. And so each tribunal, for my part, is going to have to look at this really carefully in its evaluation and decision about how to do things in the future.
Sarah Ennis, thank you so much. I know you have a meeting that you need to get to at some point, but if we go beyond that, thank you very much, and do slip away.
My pleasure, thank you.
Okay, thank you very much. Sarah Anthony, if I can come to you now as the Vice President of the Court of Protection. Now, the Court of Protection, as everybody knows, seeks to protect those most vulnerable in our society, those who lack capacity, and makes extremely important decisions in their best interests. If I can raise the same questions I did to Sarah Ernest, what effects are happening in the Court of Protection in terms of the physical lockdown and the work of the court in general?
Well, as you are very much aware, Sam,
Join the meeting.
Litigants in the Court of the Protection are right in the vanguard of this awful pandemic. And in the days before the Prime Minister's announcement announcing lockdown, I was very concerned indeed as to how the Court of Protection was going to cope, because its role was going to be central, because some of the complex issues were inevitably going to come before the court, and because, as you and regular users know, it is perhaps the most under-resourced court in the entire system. If you go through into the administrative section of the First Avenue House, as I did when I became the Vice President, it is a life on Mars experience. You go in and there are rows and rows and rows of manila files, and the coding system is a sticky star on the files, and a transfer of a case from First Avenue House to the RCJ still literally means a trolley down Chancery Lane, not the press of the bottom of the court to do. And I was profoundly apprehensive as to how the court was going to cope. But one thing that is the great strength of the Court of Protection, I think, is the quality and calibre of the judges. I am very, very fortunate to have at every level really impressive judges. We have the most phenomenal support at First Avenue House and indeed nationally from the administrative staff. And if I may say so, the calibre and quality of practitioners in Court of Protection is also extremely high. And so our approach to this was to use all these strengths as our starting point. And we put together something called the Hive, which you may have read about, which is a kind of think tank that allowed us to speak to the doctors on the front line. We've had most amazing conversations with very, very senior consultants who have come in off the wards and onto video link to tell us what is happening, whether the Nightingale wards are going to cope, what the likely applications might be. and I've had this week similar conversations with care home specialists and some senior care home directors. And to my astonishment, everything has worked far, far better than I could possibly have expected. The nature of the welfare work in the Court of Protection is that it is not essentially adversarial. There are different perspectives, either on the medicine and as to where best interests lie. And unlike the equivalent in the family courts, we're not often looking to find blame. When you're looking to find blame and responsibility, I'm not sure that remote hearings are as necessarily as straightforward. But here we're not. That the advocates have rallied. Vikram Sachdeva, who is a member of the Hive Group, has put together a reinvigorated code of advocacy, which is designed to bring the conventional strengths of advocacy into this remote platform conferencing arrangement. The issues are identified up front at the beginning. They are narrowed down beforehand as much as possibly can. And there has been a real determination to make this work. I think, if I may say so, I think it's been extremely good for advocacy. So from the outset, I don't know of a single case at Tier 3 in the Court of Protection that has not been dealt with remotely. Some have settled because there's been a greater spirit of cooperation and compromise and people speaking together on separate remote meetings. But where cases have been listed as contested hearings, I don't know a single one that hasn't been able to go ahead. Now that's not the same in the family division. It really indicates that the nature of the dispute in the Tier 3 cases is perfectly receptive to the kind of structures that we have.
And so, Sir Anthony, plainly some of those issues require determination, having hearing or having heard from experts. Is the court functioning on the basis that you are able to hear expert evidence and make determinations?
Yes, because in fact, I think we have been slightly over cautious in taking evidence, expert evidence remotely in the past. Old judges would say, well, I'd quite like to see the white of his eyes, and that sort of remark. But you can't, these are incredibly busy people. They are in the midst of a health crisis, and they can simply come off the ward, get onto a laptop, calm down, give their evidence, and then go back to work. It's obviously the right way to deal with it, rather than have them come halfway across the country sometimes, as we have done. And the evidence of an expert, I think, is perfectly receptive to proper assessment in the vast majority of cases in the circumstances such as we're speaking to each other now.
Yes.
Perhaps sometimes it's a little bit more difficult in relation to family, but not to such a degree that it makes the hearing unfair or compromises the integrity of the process.
Sir Anthony, in terms of the use of technology in the Court of Protection, first of all, it sounds as if it's been it has been useful, number one, but do you think it's opened up avenues of evidence perhaps that could be given by the protected party, so the person who potentially lacks capacity?
I do. So in the course of the last fortnight, I've heard from two completely different sources. From the doctors, something really rather remarkable. Now, you have to put yourself into the clinical reality. The doctors have the patient with them, but unlike in a pre-COVID time, They don't have the relatives around to speak with and to explain things to. So they have to make specific arrangements for meetings like this during the course of the day. And some very senior consultants, won't say who, have said this has transformed the quality of our conversations. There's some real frankness, a real appreciation that we can't actually perform miracles. We don't know everything. We are just doing our best. And they have been able to get P's views across to the doctor in an incredibly coherent way very often. And so, in fact, the consultants say to me, these are the sort of conversations, particularly at end of life, in end of life scenarios, that we should have been having a long time ago. I was at that meeting. Sarah Caswell, who is a member of the High Group, the new official solicitor, was there. We both will regard the meeting as one of the most important that we've ever, either of us ever attended. And then only this week I had a similar sort of conversation with the care home specialist, because I've been extremely concerned about what happens to those with dementia in care homes who don't want to be there, whose families don't want them to be there, and where the virus is raging through the home. And of course, detention, if you like, there can only be authorised following proper assessments, and it hasn't been possible to get the assessors into the homes. These are massive issues of civil liberty. But what has started to happen is the family, the care staff, who are often very well known to P, as you know, and have become de facto substitute families in some ways. The carers, the family, and the doctor triangulate so as to evaluate capacity remotely in sometimes very, very challenging circumstances. And the very senior people I was speaking to have said that they have been able to negotiate remote assessments of mental capacity successfully in the majority of cases. And after this, in future, we will revert to this system of triangulation, because they are getting to know more about P, and the decisions in relation to assessment sometimes become far more valid. So I think that there have been some positive. The negative, I'm afraid, as I realised as Easter approached, and I'm trying to address now in the new term, is that it is absolutely exhausting to be having video hearings every day. I have never been as tired as I was when we got to Easter. The level of concentration, the anxiety for those of us unfamiliar with conducting cases in this way, the challenge for me of being on screen and suddenly dropped into electronic bundles for the first time in my life. This is truly, truly exhausting, as I know it is for many other judges. So I think there are certain things that we have to learn as to how to make these hearings less exhausting and more manageable. And this is not just my experience. I've heard a lot of people say this. And there's a very good expert at Salford University, Professor Brian Cox, who's done some work as to how we might be more effective in these kinds of...
Yes. So Anthony, thank you very much. Just one final question, if I may, that having adapted in the ways that we have to undertake remote hearings, in the future, is it reasonable to say that we may continue with it in some cases where it is difficult to get people all around the table in one room, as it were, and it might be much easier to have an online hearing?
I certainly would see a place for remote hearings in the future. What the ambit and extent of that will be is difficult to be clear about. But what it might do is improve in due course access by P to the process, because they are very rarely there. And if there is an option in the care home or in the hospital like this, more may want to take it up. It's not a possibility at the moment, but that may be one of the positives.
I'm very grateful. Thank you very much, Sir Anthony.
Thank you.
If I then can move to Sir David, who's the judge of the Commercial Court and the Technology and Construction Court, from the jurisdiction of the Court of Protection to yours, where things are extremely adversarial, how have you found in your jurisdiction how have you found the workload? Has it continued?
Well, by and large it has, but I think I should say, by way of preface, that if the only problem that I face is the adversarial system compared to the challenges which are being remarkably overcome by the two previous speakers, then I consider myself very fortunate indeed. The position is this, that in both the Commercial Court and the TCC, we have been running at about 80% capacity. That is, in terms of the cases which were listed and remain listed and which are dealt with. Trials are not adjourned routinely. In one case, it was because a witness was literally unable to travel because of lockdown, or because a witness in another country is self-isolating, not, as it were, because the process was likely to be remote. In fact, in the Commercial Court, it so happens that we've heard marginally more cases than we did at this time last year. So far as TCC is concerned, all short hearings, that is up to 1 to 2 days, have been listed and heard remotely. Again, the 20% drop-off in business has largely been due to the adjournment of trials because of difficulties with factual witnesses and expert witnesses, or occasionally some IT problems. So it's a different scenario. The notion of doing a trial, even a long trial, remotely, it is now something which we are all becoming familiar with. So, for example, on the 8th of June, I'm starting a quite significant 8-week fraud trial, and all the parties wanted for that to go ahead remotely. We hope that at least some of it may no longer need to be remote by the time we approach the long vacation. But we are gearing up to that and having the technology ready to do it. In that sense, it could be said that we have come perhaps as close to business as usual as we could, but there is one significant downside to the present circumstances, which is it's all very well doing things remotely, but the QB judges who sit in the Commercial Court and the TCC are very likely to be called upon in the autumn and into the beginning of New Year to hear serious criminal cases on circuit and in London, all of which have been adjourned by very few exceptions. And there is obviously a huge imperative to get those cases tried as soon as possible. What that means, therefore, is that, as it were, the staff in the roles building is likely to be somewhat depleted. So our ability to get cases back on which have been adjourned will be somewhat restricted.
Thank you, Sir David. So in terms of commercial and work in the Technology and Construction Court, do you think that that work is suitable to be dealt with by way of remote hearings, be it telephone or video?
Well, I think what is interesting, first of all, is we did some telephone hearings before for short matters. That worked all right, but there is the question of public access, which telephone hearings does raise as a problem. And in one way, now that we are doing so many hearings remotely, if it were possible to do a telephone hearing with the ability of others to join in, I for sure would now simply do it by Skype. It's actually easier, it's cheaper for the parties, because they don't have to pay for a conference call person. As has already been mentioned, it's going to be recorded in any event, and that makes it much more straightforward. As previous speakers have said, in an ideal world, for the most part, if there is to be a trial, there are advantages, and they're not necessarily ones that have to be there for a fair trial, but there are advantages which can be gained only by having the parties in court. But I entirely agree that there is going to be a movement on the part of practitioners, and I think judges, on a case-by-case basis to say, well, look, this is really just a point of law, or it's a point of law and some expert evidence, some of which may have to be given orally, quite possibly from experts who don't live in this country in any event. In those circumstances, there may well be strong arguments for saying that the hearing can be just as fairly conducted remotely and probably more efficiently so far as time and cost is concerned. What you do, however, have to build into all of that is the undoubted point that Sir Anthony mentioned, which is, funny though it may seem, it is more tiring to undertake this process. Even if you can hear all the arguments perfectly, even if you can navigate smoothly an extensive PDF trial bundle of several thousand pages, that means you need more breaks in the hearings. It may mean shorter days, but that has to be taken into account when you work out how long the hearing is going to be.
Thank you, Sir David. And in terms of the hearings that you've conducted thus far, would you have any practical tips that you could give to practitioners in terms of how best to prepare for cases, be it as simple as bundles or skeletons, etc.?
Yes. First of all, there's nothing wrong in my book in having an electronic PDF bundle, which I'm now beginning to get used to, but it does take some time. That should be provided well in advance so that the judge and or their clerk can check that there are no glitches with it and it can be smoothly navigated. The existing PDF software, which we have, enables us to highlight sections just as we would do with a highlighting pen on a paper bundle. Just must have to make sure it's fit. The way we usually do that is to ask the practitioners to have a remote test before the actual hearing. It may be no more than 5 or 10 minutes, and then we can check that everything is in order. So far as the particular platforms, the ones that we use the most, because we have them, is Skype for Business, and we occasionally use Microsoft Teams. Although this seminar is being conducted by Zoom, the present judicial guidance is that it's not a recommended system so far as court hearings are concerned, because there are still security issues. But of course, this is a moving feast, and we may find next week or the week after that those in HMCTS looking at that will say that they're now satisfied about it. Unmuting your mic is an important one. So far as skeleton arguments are concerned, it's pretty much the same as it was before. They need to be produced in advance, and the parties need to take account of usually a mid-morning or a mid-afternoon break. Those are the real tips. It's helpful for the judges not to be bombarded with suggestions about alternative platforms. There are lots of them out there. Some firms may prefer one rather than another. I'm familiar with a number of different ones, but if you bear in mind that, at least for some judges, this has been quite a steep learning curve, it's much better for us if we can stick to 1 or 2 comfort zones, at least for the foreseeable future. And if that means the solicitors may have to acquire Skype for Business, whatever cost it is, then I'm afraid that's the price they have to pay. That's the only way that we can work in a sort of proportionate way going forwards.
So David, thank you very much. So Gillian, if I can now come to you, you are obviously the Administrative Court Liaison Judge for the Northern Circuit, and I think you're currently sitting in the Administrative Court in Leeds, which is perfect timing, albeit virtually. Your court plainly deals with very important issues about the lawfulness of decision-making of public bodies, which perhaps is quite important during this period. How have you found in the Administrative Court the effects of the physical lockdown in terms of the work in the Administrative Court generally?
Well, the main effect that there's been is the closure of the counters in the various district registries, and everything now has to be lodged electronically. In terms of the volume of work processed, there are no deportations taking place at the moment for obvious reasons. And so the immediates lists, those are the very urgent cases which come in, which we have to try and deal with within a day or so. My experience, having done the immediates list in the week after Easter, is the volume of work that has fallen off. It's been replaced to a degree by COVID-related litigation. So there's been quite a lot of applications lodged from prisoners, for example, with health conditions, who are saying they ought to be released either on a compassionate basis or other basis because of the COVID risks to them. In some ways, I started my first remote case today. There were one or two teething problems with the technology. I suspect that's probably my fault rather than anyone else's. Judges and technology often don't mix happily. But actually, once we got up and running, I found conducting the hearing more straightforward than I'd anticipated. I think in the administrative court, because live evidence is very rare, it's probably best suited to remote working because everything is paper-based and you don't have to worry about cross-examination of witnesses and the like. And we found the hearing, as I say, once we got up and running, worked quite well. It's a reasonably significant case with about 1,000 pages of documents. But actually I found navigating my way through the paper much more straightforward than I thought. I think the watchword for practice is to remember that pace is important, and that navigating documents on the screen isn't, well, I certainly don't find that quite as straightforward as hard copy documents. And so don't go too fast. I had to remind counsel who were before me not to move too quickly through the papers because, as I say, negotiating on a laptop, somewhat elderly laptop screen, not as easy as having a hard copy bundle. The skeleton arguments were well written, but brevity is always key. And I think this will usher in a new age of remote working. And I think that will inevitably mean that there will be increased pressure on practitioners not to overload the court with papers, to only really file what's essential, to keep skeleton arguments, which is a trend that's happening already, obviously, but to keep skeleton arguments on the skeletal side rather than the obese side. But I, for my part, think that we will see over the next year or two, when we leave lockdown and things get back to normal, that there will be practice directions and other matters which will usher in a new age of remote hearing. I think the thing that needs to be thought about is the principle of open justice. While at the moment judges are sitting in their kitchens or studies or wherever, and the parties are at home, that can only be a temporary measure because it does have the effect of excluding the public, which obviously is very undesirable. And so I think the new age of remote working, which I have no doubt will arrive, we will have to solve the problem of how to allow public access. I, for my part, perceive it as the judge sitting in court in the RCJ with the parties appearing over video links, so the public can come in as they could pre-lockdown to listen to the hearings and hear what's going on. But subject to that, I think we will rapidly just all get used to the new normal, which is remote working, things being filed in soft copy rather than hard copy, and it will become second nature in very much the same way that in a court of appeal criminal division, where defendants are never produced, appellants are never produced now. It's all done by video link, and none of us thinks twice about it. And I foresee something very similar happening in the work of the courts on a broader basis.
And so, Julie, in terms of the work of the administrative court, do you think, and in the way the hearings operated, do you think that it gives itself to be dealt with by way of remote hearings? And you were mentioning,
I think the administrative court probably more so than any other court, because it is almost exclusively, as I've said, paper-based. When I was at the career at the bar, I spent most of my time in the administrative court. I think I did 2 cases where we had live evidence, but it's very, very rare, as most of the practitioners on this meeting will understand. And so I think the work of the administrative court probably par excellence does lend itself to remote working, simply because you don't have the issue of witnesses, etc., and concerns about that. You can just do it as you would do it in the ordinary way. It's just you're doing it over a computer screen rather than actually in court.
And so, Julian, in terms of the administrative court and the regionalisation which happened some years ago now, in
Yes.
effect, the current restrictions hamper regionalisation in some way, don't they? In the sense that anybody can attend a remote hearing, and you don't.
Well, yeah, I was thinking about that point actually when I was just thinking about the remarks I was going to make. I mean, I think yes and no is the answer. I think it does destroy regionalisation in as much as I'm not sitting in Leeds as I would be otherwise. I'm sitting in my house near the home counties, hearing council in Newcastle, council in Leeds. And so in that sense, it's more disparate, and it does cut the regional connection. But in another way, because it's as if you're all sitting in the same room together, I think it brings people in a way closer together. I mean, the judge, I'm not physically sitting in Leeds, but I may as well be. So I think sort of yes and no. I think yes and no is the answer. I think we will go back to regionalisation. I have no doubt that once the lockdown ends, I will be sitting in Manchester and Leeds, as I need to do as part of my duties as administrative liaison judge. But I had a sense of closeness, with council. We were able to speak perfectly naturally and normally, subject to 1 or 2 technical glitches, and so I didn't particularly feel disconnected.
So for the current status quo, the normal practice direction applies, which is apply or issue at the local regional court. Yeah.
Absolutely. The most significant change as far as the administrative court is concerned is that, and there's guidance online which people can access, the bundles have to all be now filed electronically and put in a particular format, which, as I say, I did a week of immediates a fortnight ago. People don't seem to have any difficulty complying with it. In many ways, the paperwork was in much better format than it sometimes is.
And I think we've seen perhaps an example of the limits of technology. I think Sir Julian's frozen there. We'll wait a second to see if he returns. Otherwise, no, doesn't look like it. Well, I think that brings us to our natural end to this event. Thank you again to all of our speakers, all of the judges for attending and accepting the invitation.
Sam, before we go, may I just say on the transparency point that Julian had raised,
yes.
In, I would say, half of the Court of Protection applications, as I've heard, the press have joined the hearing remotely too.
Yes.
It may be less than perfect, but there is still some transparency there.
Yes, of course. Yeah. Thank you, Sir Anthony. It falls on me just to close this event. Again, thank you to all of our guest speakers and those who've been in conversation with me, as it were, about the different jurisdictions. I hope you found it useful. And if anything comes out of it, I think it is this, which is that we've probably been brought to a situation where we've worked as far as we can to keep the show going, but also use technology. And use technology in a way which hopefully may in the future define our best practices, and perhaps in the future a lot of the hearings which would have been in person will now be by video. But let's wait and see. Again, thank you for coming, and I hope you're all well, and we look forward to seeing you in the future. Thank you very much.